Hi everyone and welcome back to another video. In this video we're going to be talking about Axel Rudakubana, who has today, which is Monday the 20th of January 2025, pleaded guilty on day one of his trial to the murder of 3 children in Southport. Now I'm going to explain about some of the misconceptions that I've seen cropping up online about pleading guilty on day one of a trial, and then I'm going to briefly talk generally about the sentencing of individuals who have been convicted of murder. I'm not going to delve into any of the political commentary about who knew what and whether or not there were any kind of cover-ups. That's not what I do. I'm just going to talk about the law and how the law applies in this case. Welcome to my channel, Andy on Crime, where I talk about high-profile criminal cases and other aspects of criminal law in England and Wales. The first thing that I'm going to do in this video is talk about the facts behind this case and briefly recap them. Now I know most people watching this video will be familiar, but it is always useful to go back over them. So on the 29th of July 2024, the then 17-year-old Axel Rudakubana carried out a brutal knife attack at a Taylor Swift themed dance class for children in Southport in England. This resulted in the deaths of 3 children, BB King, who was 6, Elsie Stankham, who was 7, and Alicia de Silva Aguirre, who was 9. Now, in addition to the 3 children who were murdered, 8 others and 2 adults sustained injuries, and Rudakubana was arrested shortly after the attack. Now, it's been revealed that prior to the attack, Rudakubana had been referred to the UK's counter-extremist programme called Prevent on 3 separate occasions due to concerns about his interest in violence and school massacres. Now, despite these referrals, it's been said that he was not deemed a terrorism risk and did not receive any intervention or action to prevent him from carrying out the attacks that we later saw in July of 2024. Now, following the attack by Rudakubana, claims about his background surfaced online, which led to widespread unrest throughout the country and a number of anti-immigration protests or riots, which saw over 1,000 people arrested and charged with various crimes, including violent disorder and inciting racial hatred. And on the 20th of January 2025, so today as this video is recorded, and as I said at the start of this video, Rudakubana pleaded guilty at Liverpool Crown Court to 3 counts of murder, 10 counts of attempted murder, as well as other offences such as producing the toxin ricin and possessing an Al-Qaeda training manual. Now, the trial judge has indicated to Rudakubana, as is the case in all sentences involving murder, that a life sentence is inevitable. The only question will be how long the minimum term or tariff will be, or whether or not he will receive a whole life order. The sentencing of Rudakubana is scheduled to take place this week on Thursday the 23rd of January, and I'll look to do a video once that sentence has been delivered, so that I can go through the judge's sentencing remarks and explain how he came to the sentence that he did. So I'm now going to talk about pleading guilty on day one of trial and just deal with a couple of the misconceptions that I've seen cropping up online. I've seen there's been some sort of suggestion that there has been a deal struck with the prosecutor for Rudakubana to receive a reduced sentence in exchange for pleading guilty. That simply doesn't happen in England and Wales. The prosecutor has no power to determine someone's sentence. That is reserved solely for the judge. Now, when it comes to sentencing, what the prosecutor will do is assist the court in the categorisation of the offence. So they'll look at the facts behind the offence and then use the Sentencing Council guidelines, which are widely available. You can look them up online if you're interested, and they're available for most offences. The prosecutor will look at the sentencing guidelines and argue why the prosecution feel it should fall into a particular category, which will then attract a starting point and range for a specific type of offence. Defence counsel will then stand up and argue or mitigate on behalf of the defendant and may argue that the sentence should be in a lower category or indeed agree with the prosecution. But the person whose decision it is as to whether or not an offence falls into a particular category is the judge and the judge alone. In America, and it's not a jurisdiction that I practice in, there seems to be a lot more involvement with the prosecutor in terms of deciding sentences. That simply doesn't happen in England and Wales. So why then would someone plead guilty on day one of a trial as opposed to pleading guilty at an earlier opportunity? Well, there might be a multitude of reasons for that. Sometimes people simply just bury their head in the sand. They don't want to admit that they've done wrong, and they drag it out until the point at which they're about to face a jury in a criminal court and decide at that moment that they're going to plead guilty. Another reason might be those newly qualified barristers who are going through pupillage and who practice in the magistrates' court will have seen this time and time again, is that witnesses often don't turn up. So if, for example, in domestic violence cases where it's the complainant's word against the defendant, if the complainant doesn't turn up and there's no good reason for their absence, then often the court will indicate to the prosecutor that the case will proceed, at which point the prosecutor will have to offer no evidence. So the individual is worth not pleading guilty at an earlier opportunity in the hope that the complainant doesn't turn up. If the complainant does turn up, often what you'll see is that the defendant will change their plea from not guilty to guilty, and then they'll proceed straight to sentence. So there could be a tactical reason for it. Now, there is an incentive for someone to plead guilty at the earliest opportunity. If someone is charged with a criminal offence and then pleads guilty at the first time that they're arraigned, so that's when the charge is put to them and they're asked whether they plead guilty or not guilty, if someone pleads guilty at that opportunity, they are entitled to 1/3 off of the sentence that they would have received had they been convicted after trial. But that is on what's known as a sliding scale. So the later in proceedings that you plead not guilty and then change your plea to guilty, the less credit that you will receive. Now, normally someone who pleads guilty on the day of trial, so we call that at the door of the court, will be entitled to a 1/10 reduction off of their sentence. So in this case, it's quite likely that Rudakubana will receive a 10th off of his sentence because he has pleaded guilty. So there is an incentive for someone to do so. The earlier you do it, the more credit that you get. The later you do it, the less credit you get, and if you're convicted after trial, you get no credit whatsoever. And how that's worked out is that when you categorise an offence and it has a starting point and a range, the court will work out what the sentence would have been had you not pleaded guilty at the earliest opportunity. So for example, if you're given a sentence of 3 years, the judge will then reduce that by 1/3, so the individual will subsequently receive 2 years. I'm now going to talk about sentencing for people who have been convicted of murder. Now, those of you that watch my videos frequently will have heard me say this, so apologies for going over it again, but anyone who is convicted of murder in England and Wales, and I'm talking about just murder, not manslaughter or other alternative offences, this is purely murder, they will receive a mandatory life sentence. The only question is how long the minimum term or tariff will be, which is the length that an individual must serve before they are eligible to apply for parole, and then it'll be for the parole board to decide whether or not they are safe to be released into the public. In exceptional cases, an individual can receive a whole life order, and I've done a video which the link is above to every individual at the time of recording that was serving a whole life order. Now in this case, you've got an individual who has been convicted of 3 murders. Now in general, those types of cases would be ones where a whole life order would certainly be a realistic option. But Rudakubana is or was 17 years old at the time the offence was committed, and the courts treat individuals under the age of 18 differently to adult offenders. So in a case like this, where the individual was over the age of 21, the individual would be looking potentially at a whole life order. Now, the Sentencing Act of 2020, Schedule 21, outlines the criteria that the judge will look at when considering the appropriate starting point for someone who has committed the offence of murder. And I'm now going to show, and you should see it on the screen, Schedule 21 of the Sentencing Act 2020. And if we look firstly at Section 2, subsection 1, this outlines the criteria for a starting point of a whole life order, and it states that the court considers that the seriousness of the offence or the combination of the offence and one or more offences associated with it is extremely high, and the offender was aged 21 or over when the offence was committed. This is when it would be appropriate for a whole life order to be given. And subsection 2 talks about cases that would normally fall within this category, so would attract a whole life order. And for example, the murder done for the purpose of advancing a political, religious, racial or ideological cause. And the killers of David Amos MP and Joe Cox MP both received whole life orders, as their murders were done for the purpose of advancing a political cause. In this case, you have an individual who is 17 at the time of the murder. So ordinarily, the criteria, subsection B, the offender was aged 21 or over, is not met. That doesn't mean that a whole life order cannot be awarded. It just means that ordinarily the court would have to go out with the guidelines for the appropriate starting point for a whole life order to be awarded. If we jump down to subsection 3, this is cases that do not fall within subsection 2, but is the next highest starting point for an offence of murder, and that is a minimum term of 30 years. And you can see under subsection 3.2 some of the categories that fall within this. And subsection 2F talks about the murder of 2 or more persons, as is the case in this case. So if Rudakubana was 21 or over, he would be expected to receive a starting point of 30 years under this criteria if the judge didn't feel that a whole life order was appropriate. But if we just jump down to this table at subsection 5A, it then gives a conversion for someone who is under the age of 18. And you can see there that Rudakubana was 17 at the time of the murders. So if an individual was deemed to meet the criteria for paragraph 3.1, so that's a starting point of 30 years, the court, because of the individual's age, will have a slower starting point to reflect their age. So in this case, someone who has committed a murder at the age of 17 that falls within that category would be looking at 27 years. So I'm not saying that that is the sentence that is going to be awarded, but if you're looking for how the court will approach the sentencing, they will have to take into account his age, because that is what the legislation under the Sentencing Act 2020. Now, when the court considers the offending as a whole, there is a possibility that the judge thinks that actually, given the seriousness, the murder of 3 children, the attempted murder of 8 children and another 2 adults, along with the other offences, that a whole life order is appropriate. But if you look at the Sentencing Act, Schedule 21, this is what someone who meets the criteria would be looking at as a starting point before any aggravating or mitigating factors are considered. Now, I'm going to do a video on the sentencing remarks of the judge as they are known, and then you can understand his approach to how he came to the sentence that he will do. But the bottom line is he will receive a life sentence. The only question is whether there will be a minimum term, or whether, despite his age, which will be a big factor in terms of sentencing, rightly or wrongly, the judge will either set a minimum term or award a whole life order. That's all for this video. If you do have any comments, then please drop them down below. If you did find this video informative, then please do give it a like. And if you'd like to see more from me, then please do subscribe to my channel. Thanks for watching. Take care.